Hello viewers, welcome to our program on immigration and you. I am your immigration attorney Michael Fulwani, and once again we have with us attorney David Nachman, my law partner. David, welcome.
Thanks so much, Michael. Always a pleasure.
Thank you.
Happy New Year to everyone who is...
Very Happy New Year to all of you. In our previous programs, and continuing our programs are based upon the executive action of President Obama. We talked about in the previous program about DACA, the childhood arrivals. We talked about DAPA, the parents of green card holders and citizens who are unlawfully in the US. And now we are going forward with another subject of a provisional waiver. Now, before we discuss about that, I'm going to request David to talk what is a waiver. Provisional, there's a waiver already for long periods of time, right. Ever since I've been in this country practicing the law. Right. We have been doing waivers for people who committed fraud and all that. This Absolutely. Is something you will talk about, but basically explain what is a waiver.
Okay, well, I think that the best way to explain a waiver is that it's an exoneration or an ability for the government to exercise its discretion. And there's actually they use a special term, and it's important to just point out to our viewers, it's called extreme hardship. So if an individual is able to demonstrate extreme hardship to a qualifying relative, they're able to obtain a certain type of waiver. Now, as Michael pointed out, there are waivers of certain fraud provisions, but there are also waivers for what's called a basis, and there are waivers for a certain basis of inadmissibility. Fraud is a basis for inadmissibility. Another basis for inadmissibility has to do with the accrual of unlawful presence. So in 1996, the Republicans had control of the immigration law, and they passed some very draconian laws. One of them had to do, it was called IRA, the Immigrant Responsibility and Reconciliation Act. And what happened was Section 212A9 of that law, that provision basically says that if you accrue 180 days or 1 full year of unlawful presence, then if you leave the country, you'll trigger what's called a 3 or 10-year bar. So what happens is, in order for a person to go and pick up their green card when they're sponsored, let's say, by an immediate relative, they would have to go to the foreign consulate, and that what they would do is present themselves for the green card, and the officer, of course, would adjudicate the case. And if the individual had accrued unlawful presence, either 3 years or 10 years, they would deny the case based upon the unlawful presence. And then what would happen is the individual had the ability to apply for what's called a waiver of 212A9, and they would have to demonstrate extreme hardship to a qualifying relative. Now, what happened later was, and it was only about 2 years ago, is that they implemented what's called the Provisional Waiver. And I call that the rule know before you go, because essentially what it did was it allowed you to apply for the waiver, and of course you could only apply for this type of, it was actually on an I-601A, you could only apply if that was the only basis of inadmissibility. If, let's say, there was a 9B issue, another basis for inadmissibility, you couldn't use the provisional waiver. So as long as it was just inadmissibility because of the unlawful presence, you were allowed to apply for this provisional waiver. And this means that you knew before you left the United States, so the case wouldn't be denied, you'd actually be sitting there with an approval of your waiver, so that the officer knew when you went there that your waiver was approved, and that moved things along. Now, Michael's going to tell you about how President Obama's recent administrative relief announcements in November expands that special program.
Correct. So, before we talk about the expansion, I just wanted to say a few words in Hindi.
Of course.
Waiver bole to maafinama. It's like forgiveness in Hindi. Maafinama means
exoneration. Yeah. Mm-hmm.
इसका मतलब क्या है कि इमिग्रेशन लॉ के अंदर बहुत सारे ऐसे ग्राउंड्स हैं जिसके अंदर जो एप्लीकेंट है वो इनएलिजिबल एक्सक्लूडेबल माना जाता है, जैसे कि किसी ने फ्रॉड किया, किसी ने डिपोर्टेशन का ऑर्डर है और 10 साल की बार का है, फाइनेंशियल ग्राउंड्स के ऊपर, मेडिकल ग्राउंड्स के ऊपर, सो मेनी अबाउट 32 ग्राउंड्स ऑफ इनएलिजिबिलिटी। उसमें से एक ये भी है कि अगर आप यहाँ 1 साल से ज़्यादा इलीगल रहे हैं मान लीजिए और वापस जाते हैं किसी भी रीज़न से इंडिया में वीज़ा लेने, तो 10 साल का बार है। फॉर 10 years यू कैन नॉट गेट अ वीज़ा। तो ये जो दिस वेवर, जो प्रोविजनल वेवर जो कि डेविड नाकमन ने बताया आपको, वो सिर्फ एक ही बात के लिए है, वो है अनलॉफुल प्रेजेंस का वेवर। मान ली किसी ने कोई फ्रॉड किया है, मिसरिप्रेजेंटेशन है, कोई और ग्राउंड है, तो ये वेवर उसको हेल्प नहीं करेगा। इसका सबसे बड़ा एडवांटेज क्या है? नो आई कैन टॉक इन इंग्लिश। द बिगेस्ट एडवांटेज इज लाइक दिस: in the old times when a person could not adjust their status in the US, right? He said, okay, no problem. Can I still apply for an immigrant visa in India? I say, yes, you can apply. But if you go there, the American consul is going to deny, because he is going to say that you overstayed for more than 1 year.
Exactly.
So for 10 years, I cannot give you a visa.
Right.
Okay. The person is married to a US citizen, so he is eligible for the waiver.
Right.
So the consul in the denial letter will say, however, if you are eligible for a waiver, you can apply for the waiver. Person is happy, fine, no problem. He prepares the application for a waiver, and at that period we are talking about, the waiver was granted by the immigration office in New Delhi. The consul will take the application, forward to the USCIS, and they take some time, sometimes 6 months, a year or more, because sometimes they need the file from US and all that. And on the top of that, the most important thing that for which they denied these waivers was they were not satisfied with exceptional hardship. Exactly. And that exceptional hardship had to be only to the spouse or the parent of a US citizen.
Right.
So that was a limited one. The problem was this, David. So he says, okay, I'll do that, no problem. 1 year I'll wait, whatever it is, I'll go, deny, and I'll apply for the waiver. What if the waiver is denied? For 10 years he is stuck. The wife is here, children are here, family is here. For that reason, they did not travel to India. They did not choose that option 90% of the time. They say, I don't want to take the risk.
And what did that do? It separated the families.
Separated the family and hardship.
Exactly.
The extreme hardship was one of the grounds mainly that they denied. We don't believe that is exceptional. Mere separation of husband and wife is not exceptional hardship with them.
So let's show the slide.
This is a solution to this is this, what you say. As 2 years ago, they came back with the provisional waiver, which says that, okay, here, we understand, you can apply for waiver right here before going to India. So apply for the waiver, show the extreme hardship, and if it is approved, then you can go back. But even then, we told the people that even you have this waiver, one thing has to be sure that you are not excludable under other grounds. Exactly. Because your consul says, sorry, no, 10-year bar. He says, sir, here's the waiver. Oh, this waiver is only for this, but we see you committed the fraud also. Right. No, so, then you're stuck there. Exactly. Then that waiver cannot be done locally in India now. It has to come back to the US and all that process.
I'd like to show the slide with regard to the provisional waiver expansion. So, Michael, how does the president's announcement now expand the provisional waiver program? Because this is very exciting and good information. The only problem with it, of course, is that we have to wait for some kind of a regulation. Yeah. So there's no regulation on it, but at least we're pointed in the right direction, right?
See, they expanded, first of all, before, as we said, the extreme hardship had to be only to the spouse and the parent. And the expansion is that even if that hardship is not that extreme, I mean,
they're expanding the definition of extreme hardship, but they're also expanding the number of people who would be included to include spouses, sons and daughters of lawful permanent residents, and sons and daughters of U.S. citizens.
Yeah. So included means not that they can, the hardship issue is separate. They have not been changed. Right. The hardship only remains only for citizen or the parent.
Right.
But who can apply?
Correct.
Previously, only a spouse or a parent could apply.
Right.
Now they said even if there's a child, son, daughter, who is under this situation where he has a 9B problem, he can apply for a provisional waiver, get the approval done. So they've actually added the children to this.
Right, and clarified, hopefully, what is extreme hardship, because there's not a clear definition of what extreme hardship is. So hopefully with more objective criteria, we'll be able to make a determination of what, in fact, this extreme hardship actually is.
Yeah.
With that, Michael, I'd like to turn to some of the additional administrative relief in the business context, which was announced by the President. And obviously, many of these things have not taken effect, but they're things that might take effect. So I'd like to move to the slides. The first one has to do with Worksite Compliance. So there's a discussion regarding the possibility of the creation of an interagency worksite enforcement group, which is going to identify policies and procedures that will deal with the consistent enforcement of labor employment. This is an interesting opportunity where information is going to be transferred and shared among organizations within the U.S. government. So it's possible that we may see more site visits. It's possible that employees may come under extreme scrutiny by the government and information sharing between them. Also, the Secured Community Program, which many people may be aware of because of the fact that they were given detainers, is going to be revised, and now it's going to be what's called a priority enforcement program, where individuals who are national security risks are going to be identified as being priorities for enforcement. And other sorts of things that we're going to see, number one is that we've
EAD for F4, very, very important.
Yes, absolutely. I was just going to say that. You're reading my mind, which is, yeah, so, and by the way, that's not an administrative relief that the President announced. It just happened to have been coupled with all of the other announcements that he had made.
Yeah, but that's never put in implementation. Now he's saying we'll implement that.
It's in the rulemaking process, and actually I checked this morning, and it looked like it was still in the rulemaking process, and it goes back to July. So it's been in the rulemaking process since July, but what essentially that's going to do is give the opportunities for H-4s to be able to work as long as their primary beneficiary of the H-1B, of course, has applied for either an extension under AC-21 for the 7th year H-1B or is the beneficiary of an approved
H-1 is
I-140.
has to be in a valid H-1 status.
Exactly. Has to be in a valid H-1 status. So that's one of the provisions. The other one is that there's discussion about the expansion of OPT for STEM students, which is an opportunity for students of science, technology, engineering, and mathematics. They'll be either given an opportunity to, number one, there'll be an increase in the number of STEM provisions, STEM categories, which is very nice, or two, there'll also be the possibility of increasing the duration of the STEM extension. So we don't know exactly what it means, what the President announced, but we're still waiting on that. Something very exciting. This is very good. Expansion of the national interest waiver to cover researchers, scientists, individuals who are foreign investors, researchers. So we've been using the national interest waiver in such a way for a long time, but we haven't been given the guidance that we really need. Unfortunately, what's happened is that we've used the Entrepreneur in Residence program to make arguments that, of course, the EB-2 should be granted for people who are developing jobs for U.S. workers. And if you go back historically into the national interest waiver, you'll see there's a case called Mississippi Phosphate, which in the early 90s interpreted the national interest waiver, and there's actually a provision in the Mississippi Phosphate case that talks about improving the wages and working conditions of U.S. workers. So I think what the President has essentially done is grabbed onto that old case and brought it to the forefront and said, this is what we want to see. This is good for the U.S. economy. So that's, I think, what he's talking about there. But of course, we're still waiting for further guidance. Something that's very exciting is Parole in Place, which is a program that's been around for a long time. Parole in Place is a very easy type of program where you can make an application to the district office to keep someone here in the United States who's developing jobs and wages for U.S. workers. It's on a case-by-case basis for inventors, researchers, and founders of startup enterprises. And there's discussion about how much money does the startup enterprise have to have. So we're still waiting for the FAQs on that to see how that's going to go.
What about entrepreneurs?
They're going to be swept under the national interest waiver, and they're going to be swept under the Parole in Place.
Jobs, that's included.
Exactly. So the focus is really going to be on how much these individuals are adding jobs and money to the U.S. economy. So as I said in my prior programs, if you're not already buying stock in the English language programs and you're not already buying stock in, what was the other one? There was another thing I said that is going to be very valuable. Now's a good time to become friendly. With your accountant. Yes. Now's a good time to become friendly with your local economist, because economists are going to be giving expert opinions regarding the ability for foreign nationals who don't have status to stay in the United States because they're contributing jobs or contributing to the U.S. economy.
The bottom line is what you said. Thank you very much, David, for coming on the program, and thank all of you for watching the program. Please make sure to keep us watching on ITV Vision of Asia every Saturday and Sunday at 11:45 a.m. Thank you very much and goodbye.